our workshop. We are sorry we are starting a little bit late. Of course, we are Nigerians and we are quite familiar with our African time, but we are sorry we had to observe that this morning. We quite apologize to our friends from America. This is African. We observe a little bit of African time just to ensure everybody gets here on time. Thank you so much for coming. And before we start, we want a volunteer to lead us in opening prayer. Muslim, Christian, please a volunteer to lead us in opening prayer. Thank you. Please could you come to the front. Amen. Thank you very much. Thank you very much. And as I've said before, you're all welcome to this workshop. And as a way of introduction, this is the fourth workshop we're doing in Nigeria. This is the fourth workshop we are doing in Nigeria. We did one in December 2016. We had another one in Lagos Business School, Lagos. We had another one in Transcorp Hotel, Calabar in February. And in May, we were at NILES, Nigeria Institute of Advanced Legal Studies, Lagos, where we had another workshop on oral advocacy. And as an offshoot of that program, there was a clamor for more of this for the northern part of Nigeria. That is why we are having a repeat of that workshop again in Abuja. So indeed, you are highly, highly, highly welcome. And before we start, I will just do a brief profile on what CWAG we do. Of course, CWAG is a Conference of Western Attorneys General. Conference of Western Attorneys General. The Conference of Western Attorneys General is a bipartisan group comprised of the chief legal officers of 15 Western states and 3 Pacific territories. Members include Alaska, Arizona, California, Colorado, Hawaii, Idaho, Montana, Nevada, New Mexico, North Dakota, Oregon, South Dakota, Utah, Washington, and Wyoming. The conference also includes the Pacific jurisdictions of American Samoa, Commonwealth of the Northern Mariana Island, and Guam. Associate members include the states of Arkansas, Florida, Iowa, Louisiana, Michigan, Nebraska, North Carolina, Oklahoma, Rhode Island, Texas, Vermont, West Virginia, and Wisconsin. CWAG's primary function is to provide a forum for chief legal officers of member states and jurisdictions to cultivate knowledge, cooperate on concerns, and coordinate actions which improve the quality of legal services available to members. CWAG focuses on common areas of interest to the West: water, fish and wildlife, public lands, minerals, environmental protection, and Indian law. Interest in organization has been generated from states, countries, and individuals from outside the West due to the evolution of law on these matters and the universality of many of these issues. Since 1982, CWAG has employed its own staff to coordinate litigation, legislative efforts, and information to assist Western states on both regional and national levels. CWAG provides assistance to members by serving as a central clearinghouse for information and legal strategies, facilitating interstate working relationships, and enhancing expertise by providing timely information. CWAG plans and sponsors an annual conference along with several topic-specific meetings such as Indian gaming seminars, taking seminars, and energy issues seminars. These conferences are attended by attorney generals and their staff from both within the CWAG region across the country and have had international exposure with participation by both Canadian and Mexican attorneys general. In fact, in this year, we had the AG of Cross River State attend, and it was indeed a wonderful experience for all the participants. CWAG maintains communication with federal officials and congressional contacts, monitors legislation, and provides questions for confirmation hearings. CWAG works closely with National Association of Attorneys General on many projects, including issues like methamphetamines, criminal law, and identification theft. CWAG provides information and articulates Western state views on federal issues and legislation. CWAG maintains regular contacts with and initiates meetings with many federal agencies: the National Indian Gaming Commission, U.S. Department of Interior, U.S. Department of Justice, and U.S. Department of Energy regularly. Solicit input and cooperation from CWAG on matters of concern or interest to Western states. A common theme with these entities is the tension between the state and federal sovereigns. CWAG has created a channel through which Western concerns and suggestions are conveyed and answered. Like I already said, the first CWAG workshop was held in Lagos, in Nigeria, in Lagos, in collaboration with Lagos Business School. It was held on the 16th of December, 2016. It was widely attended by officials from various prosecuting agencies. Mr. Rotimi Jacobs of EFCC was also there with us. We had a very robust discussion on issues of effective prosecution. And then because of the success that was attached to that program, and then the keynote address that was given by the AG of Utah, Sean Rees, he talked about the human trafficking. Because of that, NAPTIP officials that were there present generated a lot of discussion about the issue of human trafficking, and which is what gave birth to our second workshop in Calabar on issues of human trafficking, prosecution of human trafficking, and Victims Protection Fund. That was what we discussed in Calabar in February 2017. And following that, we had the third one, which we held in conjunction with Niles. It was well attended, and it was still on the art of oral advocacy in Nigeria. And today is another day for us to rub minds together. We usually have a very interactive section. It's not just a lecture. It's for us to educate, because really CWAG is all about creating forums by which different jurisdictions can rub minds together and understand each other and gain from our experiences. Because like we know, crimes and businesses have gone cross-border. It has gone transnational. It's beyond the national anymore. We have gone beyond that. So it is good for us to have an idea, to understand each other, because our experience is robust for us. Just like businesses are moving beyond borders, crimes also follow it. And it's as it follows it, we follow our clients wherever they go. And as lawyers, we can't be contained in one state or one jurisdiction anymore, because everything has gone beyond jurisdiction now, and it has gone global. So that is why CWAG is a very good opportunity for us to meet together. So I will enjoin you during the course of this workshop to actually contribute, to actually open your mind, to share the knowledge you have, and to also learn, because that is what we are here to do. It's usually a very interactive section. You can ask questions, you can make your comment, and you have a flash drive with you. That flash drive contains all the presentations that are going to be given here, so that if you have your laptop, you can open it up and follow along as we go on. And if there is any question you have, you can note it down during question and answer time. You can ask your question. And it's important that you wear your tag. It is very, very important, because we want to make sure we have a good audit of people that are here. The hotel actually requires that we have a good audit of people that are present at this program. So you are required to wear your tag at all times. We're going to be having coffee break at a time, and of course we'll also go for our lunch. And as we go on, we'll get more information. If there is any other information to be passed across to you, it will be passed across to you. Like, I apologize once again that we're starting a little bit behind schedule, but we're going to move very fast because we want you to be able to rest, go home in enough time to rest so that we can return early tomorrow morning. And to take us in the first interactive section this morning is our friend Demi Haman. Demi Haman is a career prosecutor currently handling felony level criminal cases in Southern County, Nebraska. Demi has experience handling a wide range of cases ranging from theft, assault, and drug cases to child victims crime, domestic violence, and sexual assault. She has a particular interest in protecting the well-being of children and victims who must testify in court. Demi graduated from Gustavus Adolphus College in St. Peter, Minnesota with a BA in Criminal Justice and Sociology. She obtained her JD from William Mitchell College of Law in St. Paul, Minnesota, where she was a student prosecutor. She is licensed to practice law in Arizona and Nebraska. Upon graduating law school, Demi began working for the Maricopa County Attorney's Office in 2001, starting in General Trial Division, and moved to the Gang and Repeat Offender Division, as well as serving as a mentor for 13 new prosecutors in the Pretrial Division. After starting a family, Devi moved to Nebraska. She worked from 2008-2013 as the chief editor in Platte County in Nebraska, handling the felony caseload until she transferred to Southern County Attorney's Office, where she has been since 2013. Ladies and gentlemen, I present to you Demi Haman. Very
say it's not that you can't think of something that explains the behavior. It's not proof beyond any doubt, because we're all intelligent, creative people. I can come up with a story that explains it, whatever the charge is. But it's what makes sense. What makes sense in common sense. How many people have children? A lot of parents. I like to use an example for common sense or for beyond a reasonable doubt. One of my favorite things to do with my kids is to bake cookies. They like to eat cookies, so it works out that we cook. And let's say we bake a pan of cookies and I leave them on the stove to cool. And my child comes in and asks, Mom, can I have a cookie? And I say, no, it's almost dinner time. You need to wait. So they're very sad and they leave. And I go to do other chores and I come back to the kitchen a few minutes later and half the cookies are gone. And my child is in another room with chocolate all over his face and little fingers full of chocolate, and he's licking his fingers, looking quite happy. And I say, Ryan, what happened to the cookies? I don't know, Mom. It must have been the dog. And I look at the pan, and I look at crumbs on the floor, and I look at chocolate by his mouth and on his fingers, and I look at my dog laying on the floor. It could be my dog, but common sense tells me my child won't be eating much dinner tonight because he ate half a pan of cookies. That is proof beyond a reasonable doubt. I didn't see him take the cookies. I didn't see him eat the cookies. But I know they're gone, and I see evidence on him. And if I get very close, I could probably smell chocolate on his breath. For proof beyond a reasonable doubt, it could be my dog. It might be. It could be my. But it's not anyone else. Closer? Is that better? For proof beyond a reasonable will prove with common sense that those things match up. Does that make sense? Okay. Now, most of our cases are organized and resolved by plea agreements. Everyone has a high caseload. That's something I think is universal. We all have too much work for the amount of time we have for both us as lawyers and the courts as a judicial system to give every trial for every case. In the United States, over 98% of every case is resolved with a plea agreement in criminal matters. It's helpful for a number of reasons. Nobody has all the time to try every case. Not every case warrants the maximum penalty. Some defendants have gone through rehabilitative efforts ahead of time, and that can be taken into consideration. Maybe the state doesn't have all the witnesses that we need to prove every element of the case. And maybe it's in the interest of justice that a case be resolved with a plea agreement. I work with a lot of children, and going to trial is terrifying for them. So in a lot of cases, if we can resolve a case that meets the interest of justice and the victims don't have to testify, that can be a very positive example. Now, generally the state will make an offer in a case. My own philosophy is about 80% of the cases I handle for criminal cases are average people. They're doing the best they can with what they have. They've made a mistake. They need to learn from it. And so we have plea policies so that cases in like situations are resolved in like ways. They're not bad people. In approximately 10 to 15% of the cases I handle, the defendant or the accused is genuinely in a bad place. They need help, and the state can provide that through probation services, mental health treatment, or addiction services. In about 5% of the cases I handle, that's where I would say that the offender is actually bad, just a bad human being. They enjoy hurting people. They don't want to change. And that presents different challenges. So in evaluating a case to make an offer for a plea agreement, I have to decide that and take it seriously. A lot of times if someone just says, yeah, I'll pay you later, it's not quite the same impact as having to work ahead of time. Now, for an oral trial, in the United States, we start with an opening statement. We move through the state's case in chief, calling the witnesses in order. And sometimes that will be based on the nature of the case. We'll go through chronologically. Sometimes it's based on what witness is available and what way it makes sense to present the evidence to the court. From there, the defense will open their case. They have the chance to call witnesses, but are not required to. Sometimes the state will, after the close of the defense case, the state has an opportunity to call other witnesses as rebuttal if necessary. And then following all the testimony, we'll have closing statements. The opening statement we have in the United States is done orally to the court. And it's challenging because things always happen in trial that you don't expect to happen. In our case, maybe a witness doesn't show up. Or we'll have a motion in the middle of trial that we can't use a certain piece of evidence. Or lost or destroyed. It's always a problem. In your case, you have cases that go over time. So you're not entirely sure what's going to happen month to month. So in opening statements, you have to be careful. I will never promise a court or anyone something that I cannot deliver. So my opening statement to the court is a promise of what the state will show. Try to keep my opening pretty generic because I'm not entirely sure exactly what a witness will say. But I give it an overview, an umbrella look at the case so that the judge knows what to expect and how each witness fits into the puzzle. The state always presents evidence first. It is always our burden. We always go first. The defense has no responsibility to present any evidence or say anything at all. So if the defense chooses to present the case, it will always go second. The purpose of the opening statement, again, from the state's perspective, we don't want to present just this happened on this day and this person was hurt. You want to give a story. You want to find something that your judge understands, something they can connect to their own life, and a reason for them to care about your case, to care about your victim. The primary goal of testimony is to get your story across. Make sure job is tell me what happened on this day. Where were you? What were you doing? It's the basic questions. Who, what, when, where, why. What were you doing? Who was with you? What did you see? Tell me about that. You know, for a witness to a crime, I don't want to go through every element. Tell me more about that. They tell me where they were, what they could see. Tell me about the lighting. Tell me about who was with you. That gives them a chance to talk and to get their story and to be known by the judge without me getting in the way. For cross-examination, it's different. For cross-examination of that same witness, I want to be very precise. I want to be in control of that witness, and I want to lead them where I want them to go. I don't want them to give long-winded answers. Leading questions are the way to handle a cross-examination. When you've listened to the direct testimony of a witness, cross-examination is where you can challenge inaccuracies in their story. Maybe based on other witnesses, you know that they're lying. Maybe they gave a different story in an earlier testimony or an earlier statement. Cross-exam is your opportunity to impeach their credibility. It's also your opportunity to expose weaknesses in what happened or the theory of the other party's case. Closing argument is where you get to tie everything together. You've presented in your opening your umbrella of the case, your overarching ideas of the case. You've gone through your witnesses. You've cross-examined defense witnesses. You've poked holes in their theory. But closing argument is where you get to argue your case. And I understand you do written closings, which is nice because standing up in front of a judge after, let's say, a week-long trial, it's easy to forget an element. But in writing can be very powerful to get your witness statements in, to highlight certain testimony and exhibits. That's really an opportunity to make your judge understand your case. And if you're successful, to win your case. It's important to highlight all of the testimony, especially over, whether your trial is day to day or months at a time. It's your final opportunity to convince the court why you're right. At the conclusion of trial, we would wait for a jury verdict or for the court to give a verdict. It is guilty or not guilty, not innocent, which is why I call a defendant guilty or not guilty. And then in the United States, if we do prevail at trial, sentencing is held at a later date, usually at least 30 days later. And in that meantime, the judge will get what we call a pre-sentence report, information from the police, from the victim, information about the defendant's background, and what led them to become involved, any other criminal history that they've had, if they've done any rehabilitative steps, things like that. And the judge can consider all of those elements for sentencing. Now, I know there are a number of differences. In the United States, I as a prosecutor do not investigate. It is the job of the police to investigate the crime, to take the witness statements, to be that first reporter who can testify. As a prosecutor, we get a number of people that will come and say, I want to talk to you about this case. And that's great, but I can't take their statement. I cannot become a witness to that statement. So if someone comes to me, a family member, another witness, I refer them to law enforcement. Please have a seat, I'll get my officer to talk with you. Because I cannot become a witness. I can't have that first-hand information from someone's statement. I can't testify as to what they told me if it comes up different. So law enforcement will always start a case. Based on the information that the law enforcement provides, it's my job to file the charges, to decide, based on the police reports and the evidence they've gathered, what can I prove at trial. Trial in the United States is generally before a jury, and the number of jurors, 6 or 12, depends on the severity of the charges and the penalty that could be imposed. And that varies state by state. In Arizona, I think you have to have a sentence of at least 50 years to get a 12-panel jury. In Nebraska, where I practice, any felony offense will have 12 jurors. So that it's different state to state, much as it is here. Opening and closing statements are done orally to the court, and we do trial day to day until we're concluded. Also, in the United States, we don't have an admissibility hearing for evidence. We presume that the evidence will be admitted unless defendant files a motion through his counsel to exclude evidence. Witness statements are generally held, or we'll have a hearing on witness statements and defendant statements to ensure that they are done voluntarily. Identification of witnesses or by witnesses of the defendant are also a separate hearing. Actions by the police to search or seize property, those are also done as a separate hearing. So we presume that evidence will be admitted unless there's been a hearing and the court rules that the evidence shall not come in. So we have an exclusionary system, whereas you have a hearing here to determine what evidence comes in. We also have in the middle of trial, if an issue comes up, we also may get a portion of our evidence suppressed or not be able to use that. So that's why in opening you have to be a little careful. You're not entirely clear what's going to come in. Motions in limine, those are motions to suppress. So motions in limine deal with different evidentiary issues. Arguments that a defendant or the state may have that another party thinks is improper. So if it's not about evidence, but if it's about a trial issue, you would file a motion in limine. The overview is, on paper, very similar to the trials you have here in Nigeria. It takes a lot of work. It takes a lot of people willing to put in the effort. It takes relying on the team that you work with, whether it be other lawyers or law enforcement. And it takes your best day in court to win your case. And that is similar no matter where you go. Good luck with all of your cases. Thank you.
Thank you very much. Another round of applause for her. So she has just taken us through fundamentals of oral advocacy, an overview. So we have seen how it is done in America. And we're going to have the second interactive lecture before we ask questions, because really, like I said, it's about rubbing minds together. But before we do that, a basic housekeeping issues. The exit door, we have two exit doors. One where you came in from, and then the other one at the other side of the hall. Please let us take note of the exit doors. It is very important. And to take us in the second interactive lecture will be Scott Blake, and I will call my colleague, Mr. Afam, to come and read his bio before he goes on. He's going to take us on the theory of the case, analysis of people and Castro. One important aspect of this workshop is that we're actually going to have case analysis. We're going to have a case and we're going to analyze, and we're going to break out into sections to analyze the case, and we expect that everybody will have an opportunity to cross-examine, to do direct examination, and that is what we are going to learn from the practical aspect, because we have been doing this and we know it. So we are going to learn from each other. So while he's going to introduce it, so that we will analyze it ourselves, you will have the materials with you so that you can read it when you get back to your hotel. We're not going to do the practical examine as practical today, but you will have it ahead of time so that you will read it and understand it, so that when we are doing it, you will be able to participate, because it is all about all of us participating. It's not just about lecture. Please affirm.
Thank you so much, Mrs. Abele. Good morning, distinguished ladies and gentlemen. Scott Blake is an Assistant Attorney General with the Office of the Arizona Attorney General. Scott has been a prosecutor for over 10 years and has been with the Attorney General's office for the past 3 years. He is currently assigned to the Fraud and Special Prosecution Section. Scott primarily handles high-profile fraud cases. He also assigned to the Federal Bureau of Investigation, the FBI, Joint Terrorism Task Force. In 2017, he was named Prosecutor of the Year for the state of Arizona by the Arizona Prosecuting Attorneys Advisory Council for his role in obtaining the first successful prosecution of a state-level terrorism charge under Arizona law. As an Assistant Attorney General, Scott works closely with federal, state, and local law enforcement agencies. Previous to working at the Attorney General's office, he was a Deputy County Attorney with the Yavapai County Attorney's Office in Prescott, Arizona. As a Deputy County Attorney, he handled the majority of the office's drug prosecutions. In 2013, Scott was named Prosecutor of the Year for the state of Arizona by the Arizona Prosecuting Attorneys Advisory Council for his role in combating the sale of synthetic drugs by obtaining civil injunctions against stores that were openly selling these harmful substances. Scott began his prosecutorial career with the Greenlee County Attorney's Office in Clifton, Arizona, as a Deputy County Attorney. He handled a variety of cases while at that office. During his time with the Greenlee County Attorney's Office, he successfully prosecuted juvenile, misdemeanor, and felony matters. Scott obtained a BS in Arizona with Arizona State University in Tempe, Arizona. Upon graduating from Arizona State University, he attended law school at the University of Maryland School of Law in Baltimore, Maryland. Distinguished ladies and gentlemen, please welcome Scott Blake of the Assistant Attorney General, Office of the Arizona Attorney General's Office.
Good morning, everyone. I echo Demi's sentiments of Nigeria being a beautiful country. One thing that's really stood out to me is how polite everyone is. Everyone says hello, they're respectful. You don't see that in the United States. Everyone's busy doing their own thing, going from here to there, and I just really noticed how everyone is so polite. It's almost like I'm among family, so I really appreciate that. It's made me feel like I'm at home. This morning I'm going to talk about theory and theme. So we're going to go over what theory and theme means. Then we're going to talk about what the purpose of theory and theme